Good afternoon and welcome everyone to this session. We have the opportunity of hearing from Tom Cohn, and I'm just going to read a little bio that we have on him from the Feed Front magazine. It's on page 50 if any of you have it with you. Tom Cohn of the New York office advises clients on compliance with FTC and state consumer regulations and industry self-regulation programs, and represents clients during investigations and enforcement actions. His clients include a variety of online and offline advertisers and marketers, and his practice covers all federal and state consumer protection and privacy laws and regulations. Mr. Cohn draws on experience gained during his 17-year tenure at FTC, where he was the regional director and assistant regional director for the Northeast region. I apologize. Legal advisor to the director of the Bureau of Consumer Protection, and a litigator in the Division of Marketing Practices. As FTC Northeast Regional Director, Mr. Cohn supervised all professional and support staff and led multi-agency enforcement efforts against anti-competitive, unfair, and/or deceptive practices. And now I would like to turn the time over to him.
Great. Excellent. Thanks a lot for coming. I'm just going to... Oops. There we go. Like she said, I was at FTC for 17 years before going into private practice. And one thing that's important for affiliates to remember is that the FTC, Federal Trade Commission, is the nation's consumer protection agency, and they enforce all the laws against false, deceptive, unfair advertising, basically. And the reason I put this slide up first is because the FTC, since the 70s, has had a set of guidelines called endorsement and testimonial guides. And affiliate marketing kind of fits somewhat into those guides because a lot of affiliates are out there doing blogs and posting stuff like testimonials and endorsements and other content that easily comes within the FTC endorsement guides. Just to be really quick about the endorsement guides, the FTC basically, wants to make sure that whatever's said in an endorsement or testimonial is not something that the seller, the advertiser, couldn't say themselves. So the laws against false and deceptive and unsubstantiated ad claims applies just as much to the seller putting their own ads up as it does to any endorsements or testimonials that are used in those ads. So the other main requirement in the endorsement guides is that any connection between the endorser and the seller, like a payment or a payment in kind, like a free gift, is disclosed because that's important to the consumer's purchasing decision. So the FTC has had these guides for a long time. They just revised them in 2009. And I've been watching sort of what they've been saying and doing since those endorsement guides were revised. This first slide just explains that they investigated a retailer, Ann Taylor, for having bloggers review the next fall or spring collection, and they got free gifts, and they didn't make sure that the bloggers disclosed that they got the free gifts. So FTC gave Ann Taylor a pass and didn't put them under order or bring a case against them, but said the blogger should clearly and conspicuously disclose that payment. Fine. Well, that's all well and good and makes sense. And but the next few cases or a few matters after this Ann Taylor case, the FTC really wasn't so nice as they were to this retailer. They expect the seller to take reasonable steps to monitor a blogger's compliance, with the obligation to disclose payment or gifts they get, because that's a material connection between the blogger and the seller. So far, so good. Then, a few months after that, the FTC actually brought an enforcement case against a company that was selling video games that used a PR agency. Well, the PR agency they're aggressive, like a good PR agency is, and they sent their employees out to post positive reviews about their client, the video game company's games. And so all these PR agency people went out and posted all these glowing positive reviews, and obviously there was no disclosure that the PR agency and by connection the video game company was behind those positive reviews. So they put the company under order. They have to comply with the order. It's a court order, but I'm sorry, it's an administrative order that the FTC entered, but they didn't have to like pay a judgment fee or a fine or any monetary provisions in the order. So they were treated more harshly than before, but not as harshly as the next cases after that. The FTC made it clear that they want everybody involved, both sellers and any hired guns they use, like affiliates, networks, PR agencies, to comply with truth in advertising laws. Have the claims be truthful, substantiated, and if there's any connection between who's out there making the claim and the product, the merchant, disclose that connection. Don't pass yourselves and don't post fake stuff. Don't pass yourself off as an ordinary consumer if in fact you're working for the seller. Then you get to the next case, which was March of last year. This was a guitar instructional DVD kind of merchant. Didn't make a lot of money. It wasn't like a huge sector, certainly, but they had an affiliate marketing system where they dealt directly with affiliates, and they didn't really monitor those affiliates to make sure that the affiliates page, review page on the DVD, would disclose that they were being paid by this company, Legacy. So they, I think they maybe grossed $4 million or something. It wasn't a huge revenue figure, but they had to pay $250,000 as part of their settlement, as part of their order, and they had to obviously agree to these, injunctive provisions. Don't do this, don't do that. Make sure you disclose any connection between anybody involved in promoting your product. And they were very specific about the monitoring they wanted the company to do. Reasonable monitoring, they wrote right into the order, means you've got to monitor on a monthly basis both your top 50 revenue generating affiliates and an additional random sample of 50 more affiliates. And you got to do both of those at least once a month and terminate any bad ones, basically. So that was, sort of the next step in FTC getting tougher and tougher on bloggers, affiliate marketers, this whole area. The FTC has been kind of educating themselves on what affiliate marketing is, how it works, where they think the abuses are, and I can see since 2 years ago, 1 year ago, they're getting very knowledgeable about it, and they're getting more aggressive in their enforcement actions. So that reasonable monitoring provision in that order seems tough, 50 plus 50 every month, but then it's getting tougher. And the FTC is really cracking down on this whole area, and I'm sure you know about the FTC bringing a group of 10 affiliate marketing cases last April, suing individual affiliate marketers for publishing fake news sites, other fake content to drive traffic to, in this case, mostly dietary supplement marketers, Cohn, acai berry, some beauty products, some weight loss products, but it was mostly acai berry and similar things. So basically there were, these 10 affiliates were accused of, just posting blatantly fake stuff. Everything about it was fake, News Channel 9, whatever, and basically driving tons of traffic to these merchants through these false, fake, deceptive sites that have titles like you see here. And with headlines like that. I mean, I am sure you've seen these, and actually they're still running, but probably not as prevalent as they were maybe a year or two ago. The FTC's Consumer Protection Director, David Vladeck, he was quoted in the press release announcing these cases as saying, everything about these was fake. Every last thing, the before and after pictures, the testimonials, the statements, the claims, top to bottom, the format, the news channel, everything about it was fake. So the FTC really is now on the warpath to crack down on all fake, truly fabricated fake content that affiliate marketers publish. And they're going to keep getting aggressive and more aggressive about cracking down on this. I should mention David Vladeck, their Consumer Protection Director, is like a very aggressive former Ralph Nader litigator, and he's getting extremely aggressive across the board, not just with affiliate marketing, but lots of other cases against national advertisers, name brands, everything. So this is just one of many areas where they're really launching a full frontal assault against, deceptive practices that really bother them. This is sort of just an example of, what some of the fake pages looked like that the FTC went after. I'm sure you've seen stuff like this before, but the importance of this slide is that now the FTC has seen it, and they're very familiar with it and what it looks like. And this was an exhibit in one of their 10 cases that they brought. So not only that, but the FTC has educated themselves so much that they put together a flow chart on how it all works. You know how it works because you live it every day, but the importance of this slide is that the FTC knows full well how the whole network and affiliate marketing system works, and this was just their effort to educate the court in one of these 10 cases about how affiliate marketing really works and what happens after a consumer goes to the fake news article or the fake review or whatever and eventually buys, and tracking pixels fired, affiliate gets paid, and the importance really is that the FTC understands every last thing about this now, whereas they didn't maybe as recently as 2-3 years ago. And then getting back to the FTC endorsement guides, the FTC publishes, in addition to bringing cases, in court, in federal court, they publish a lot of business education and consumer education materials to help consumers, spot and stop and avoid fraud, but also to help businesses comply with the law. So they, put up a set of FAQs on affiliate marketing, and this is getting back to, disclosing what the connection is with the seller and how you should do it. But even more important than all this is that obviously the affiliate cannot be publishing anything that's fake or false or unsubstantiated claims, especially for things like health products and business opportunities. The only reason I included this slide is that this was a case, later, middle of last year, where they made a point of going after actually an individual who put up a fake testimonial, endorsing this particular system, this particular product or service, winning in the cash flow business. And I mentioned in an earlier slide that the FTC initially said they weren't going to go after individual bloggers like mommy bloggers. That was all the big news when the revised endorsement guides came out. Oh, they're going to go after mommy bloggers. Well, first the FTC said, no, we're not. We're just going to go after bad sellers, bad merchants. But, here's a case last year where they, went after an individual, not the seller, but she was, paid to put up a fake testimonial, and they put her under order. She didn't have to pay anything individually, whereas the company did, but they just wanted to make a point that they will go after individual bloggers, endorsers, and of course affiliate marketers. You may have heard about this case. It was filed by the FTC in Connecticut actually in November. They announced it December 1st. It's called Lean Spa, and this particular merchant was doing some really bad affiliate marketing, working with affiliates directly. A lot of fake pages that were, pre-sale pages that were posted. They really cracked down on this guy by, putting him under a temporary restraining order, an asset freeze, a receiver to take over the business, basically, and temporarily shut it down. And they also put right into their preliminary injunction, that's replaces the temporary restraining order, but they basically banned, even early on in the case, from doing any negative option marketing, any rebills at all. So, rather, some settlements in the past, you have bans in the final order that say you're banned from this business or this sector or that vertical. But here they didn't wait till the final order. Right in the preliminary injunction, they banned them from rebills, basically. And they also, even before they could charge for a trial product, they had to basically, they couldn't just say, the trial period starts here, and if you don't send it back by X day after that, you'll be charged for the trial product. They basically said, okay, you cannot, the start date of the trial has to be exactly this. It has to be the date the consumer receives, or you reasonably expect the consumer to receive the product. So they're getting a lot more hyper-regulatory than even stuff they said 3 years ago when they said just, if you're doing negative option marketing online, just clearly and conspicuously disclose sort of, what the trial period beginning and end date is, what consumers have to do to avoid getting charged, and by when they have to do it. That's kind of reasonable advice the FTC gave 3 years ago. Well, now they're getting hyper-regulatory, and they're just saying, nope, the trial period must start here and it must end there. So there was a case settlement just announced today. Oh, and the lien spot case is mentioned in that flyer I have on the tables here. I just sort of explained some more about the case. But just today, the FTC posted on their website, ftc.gov, a case they brought, I think, a year ago against Central Coast Nutraceuticals and its owners, its principals. And that was a big acai berry and other dietary supplement case where they, again, got a TRO and an asset freeze and a receiver, and they shut down the company. Basically, that case ended with an $80 million suspended judgment because he made $80 million doing this. But I think it was all suspended except for $1.5 million because that's all he had left in terms of assets and houses and things like that. But the interesting thing I read today in this order is that he basically has to agree to very, very onerous monitoring provisions, whereby if he does any affiliate marketing deals, either directly with affiliates or through any network, either way, he's got to, really monitor. Actually, I just wanted to read this from the press release that just came out today, because basically what the FTC said was, okay, under the settlement order, the defendants also are required to monitor the activities of any affiliate marketers selling products or services on their behalf, including reviewing any marketing materials used to ensure that they comply with the order. Well, that sounds bad enough, but if you actually go to the paragraph in the order, they have to, give a copy of their final order to every affiliate and every network that they want to do business with. So who's going to do business with them? That's the first question. And even if they do business with them, they have to get identifying information for every affiliate and every network that they want to do business with, get, advance, clearance, review every piece of content that affiliate is going to run either directly for them or through a network. And the defendants in this case have to review it and okay it, and they have to monitor it going forward to make sure that, even if the initial stuff was okay, they got to continuously monitor it going forward and terminate, business with any affiliate or any network if there's any bad content like fake news sites. So remember the case I mentioned about the 50 plus 50 every month? Well, this is like light years worse than that, because they have to basically, tell everyone they do business with about this order that they're under, every network, every affiliate, and then monitor every single piece of marketing material run by any affiliate or any network they do business with, and for 20 years. So, so 50 plus 50 sounds kind of light compared to what this latest order is calling for. So, like I said, the FTC is getting extremely, extremely tough on all this. So where does that all leave us as affiliate marketers? Well, I think the FTC is going to keep going after individual affiliate marketers. They sent out a lot of warning letters several months ago to a lot of affiliate marketers saying, we noticed what you posted there, looks fake or deceptive or bad claims or unsubstantiated claims, take it down or fix it, or else we may go after you. So typically when the FTC sends out warning letters like that, it means they first have surfed and found these. They may have found thousands, but they only sent out, who knows, 100 or more letters, and then they're going to go back, 6-8 weeks after that letter and check again to see if they fixed or taken down, the offensive content. And if they haven't, then the FTC will probably bring another round of 10 or more cases against another group of affiliate marketers. But even more importantly than that, they're going to go after other third parties that they feel are part of deceptive advertising, schemes. Like, they could go after ad networks, affiliate networks, payment processors, list brokers, basically anyone who's assisting or facilitating others, and and that results in what they believe is consumer injury, because the end result is, the consumer buys something based on the fake claim or the deceptive or unsubstantiated claim and consumer is injured in the FTC's eyes. So I think they're going to continue going after affiliates, maybe networks, maybe other types of third parties, and the reasonable monitoring that they need to do. I mean, when I say remember the legacy case, I would say remember that plus the Central Coast Nutraceuticals case that was posted today at ftc.gov. And you'll see that the monitoring that they're expecting both merchants and networks to do is incredibly high threshold, high standard to meet. And of course, disclose the material connections. There should be something on your every page that says, affiliated with the seller or receives, payments per click or whatever the arrangement is that discloses that there's that monetary or compensation connection between the affiliate, and the merchant. And basically, the affiliates are going to be held to exactly the same truth in advertising standards as every merchant. Claims have to be true, not deceptive, and substantiated. So in terms of what sectors, what verticals can you still, do affiliate marketing in? Well, you look at these orders that on the dietary supplement cases, both against the merchants like Central Coast Nutraceuticals and the settlements that are going to be announced soon against some of those 10 affiliate marketing cases in April, they have like incredibly tough injunctive provisions about weight loss claims, other health-related claims, and then non-health related claims. And it's kind of like a three-tier system. And the substantiation they want, the seller or the affiliate marketer to have is a really high standard. Like if it's weight loss, they want 2 double-blind clinical human studies. I mean, you're not selling the product. So you've got to get exactly as much substantiation as the seller of the product has, and make sure that substantiation meets those standards before running your content, or else risk FTC enforcement action. So I think it makes it very tough, if not impossible, for a typical affiliate to continue doing health products. Beauty, maybe not so much, but there may be FTC cases in the beauty vertical soon too. Income claims, any work at home, any biz op, the earnings claims are absolutely crucial. That's what the FTC looks at, and they also place a high priority on any money-making opportunity kinds of products or services out there, especially during the recession, the ongoing recession. They are like their absolute number one top priority is going after anybody involved in preying on what they view as vulnerable consumers during the economic downturn. So that goes from grants to mortgage refi to payday loan to a work at home. Remember Google Profits. So like any work at home or biz op, you really got to make sure that there's substantiation for the earnings or income claims that are being made. I kind of went fast, but I just want to give you sort of like the overview of what the FTC's been up to in this area just over the past 2 or 3 years. I've been coming to Affiliate Summit for 3 years now, and I think I've spoken 2 or 3 times before, and I was kind of like Chicken Little warning about, the FTC is really going to crack down on this stuff. You can't just put up any flog or article you want to and expect, no government regulator to ever, look at it or come after you. So unfortunately that, came true, and I'm kind of like I don't want to say I told you so guy, but I told you so. So I think going forward, affiliate marketers just have to be more careful than ever to try to avoid, regulatory scrutiny. It could come from the FTC, but it could also come from state attorney generals. Like the Lean Spa case, Connecticut AG was involved in. Some other states have brought affiliate marketing cases, and I think the state AGs will probably continue to bring cases either with or not with the FTC. So with that, I mean, are there any questions? I'd be happy to answer anything specific. Yeah.
I do have a question. I've noticed on some bloggers' websites, some people will state over and over within their posts that this is an affiliate link, whereas some blogs will just have a disclaimer link, like at the bottom or at the top.
Yeah. Which is best, or depending on how it reads, to a typical consumer. I don't know if they're on a PC or a tablet or whatever, but Basically, I would say at the top of every page, whatever a page consists of.
So as long as the disclaimer
Yeah, it doesn't have to
is
be.
available on each page
I don't think it has to be before or after every single blog entry.
or linked or
Right, not every single one, but I would say every single page. It should be repeated on every single page. I handled a self-regulatory challenge case that wasn't, government regulators, but it was like a competitor challenging another competitor for, not putting those disclosures up there at all. And they were, my client was behind the review site that was doing this. So, they got kind of ratted out by their competitor, and there was this self-regulatory system that the BBB runs called National Advertising Division. And basically what they decided after the self-regulatory proceeding was you should have this disclosure, receives this site is affiliated with or supported by name of seller, reviewers are compensated for their reviews or their blog entries or whatever, but some disclosure of that connection should appear. I mean, in this instance, we basically complied by putting it at the top right corner of every single page, and big enough that a typical consumer could read it and understand it. Yeah. Okay. Oh, you mean? Okay, so the affiliates do business with you, and they say they're exclusively selling to you. So they basically lied to you. Yeah, that's a cause of action, by you against them in, private sector litigation, but it's not something the FTC or a state AG would normally go after because the consumer protection regulators would view that as a business-to-business dispute and breach of contract or, whatever the cause of action is by one company against the other company or person. You'd kind of have to resolve that through private litigation. Yeah. Yes. Do you mean like reputation cleanup services or? Oh, the PC tune-up software people? I hadn't heard those rumors, but um, yeah, I can't imagine that would be a top priority for them. I mean, compared to like everything I've been talking about, to them, that right now anyway, for the past 2 years and certainly for the next year, their top priority is going to be serious health type claims, weight loss, lethal disease, cure, prevent claims. So health and safety and preying on vulnerable consumers in the recession, which is any, like I said, grant, mortgage refi, foreclosure rescue, get rich quick, work at home, biz op, all that kind of stuff together with the health and safety, to me, are their top two priorities. PC tune-up, I don't know. I could be wrong, but I hadn't heard anything about it. Yeah. In that one case against Legacy, yeah. I'm just offering that as an example because as an attorney who does this kind of law, I sort of look at the latest FTC cases and settlements as kind of a yardstick or a sort of a kind of a roadmap on where we think the FTC is going. So I kind of view that as a good standard to comply with based on the FTC's most recent enforcement action. Mm-hmm. Yeah, I guess. Yeah, because before that case, or maybe still, a lot of networks aren't writing anything down. It's kind of like there's no record keeping at all, and everything's, other than an IO, there's like there's really no record keeping that any of these parties are really doing in this space. And I found this out through handling 2 of the 10 affiliate marketer cases. It's all in the cloud, and as long as they get paid, that's all they care about, and there's really no record keeping at all. But once they're put under order, like that company, to do 50 plus 50, monitorings every month, I guess you just need to keep a record of that. And like, here's the 50, here's the record of the top 50 revenue generating affiliates, and here's why, because this one did this million, and blah blah blah, and then record the 50 and record what you did to check on those 50, I guess. But that was a case where the merchant was dealing directly with the affiliates, their own program, not through a network. So because that's what they were doing, that's what the standard they were held to was, you know, basically monitor those top 50 plus 50 more random, chosen at random. I guess you just keep a record of both those things. And I think under the order, they're going to have to produce that information to the FTC on a periodic basis just to show that they're complying with their final order. Yeah.
So it's true from Congress is involved in some of these laws and some of the states are. Where does the FTC's power stop? I'm saying, like, they make a lot of regulations. Where did they just be creating regulations? Do they suggest to Congress maybe that they should be pushing some of these things?
Not in this particular area. I mean, they're pushing Congress to do, behavioral targeting kind of legislation, but that's privacy. In this area, there's no new legislation needed because the FTC's argument, their view is that, look, this fake stuff is already unlawful under Section 5 of the FTC Act, which prohibits unfair and deceptive practices. The law's already on the books. It's been on the books for decades, and we're just applying the existing laws, the FTC says, to new areas. Same law. It's been on the books forever. We're just applying it to new areas as they come up, and basically it's such a broad-based statute, that prohibit unfair and deceptive practices in interstate commerce. Well, that's everything. So if the FTC sees it and finds it, they can go after it under the exact same law they've been going after internet marketing, telemarketing, direct mail marketing. I mean, going back decades. This is just like the next channel or the next sector as commerce evolves, and next is mobile marketing. Well, FCC is involved in mobile marketing, but I bet the FTC will get involved in mobile payments. I mean, in terms of buying this stuff on your mobile. If there's deceptive stuff going on with mobile payments and not disclosing terms and conditions and stuff like that, the FTC probably can go after that, even though it's mobile and the mobile carriers, the parties there are otherwise regulated by the FCC in terms of, the technological aspects of what they're doing. The consumer-facing stuff that they're doing, I think FTC may go after that next. So that's like the next screen. That's the next thing that's going to get big in the next few years. So they're going to move on from this area to probably mobile stuff. Yes? Yeah, it's a really small federal agency. It's unlike the cabinet departments that are huge. This is like an independent law enforcement agency. So the president appoints the 5 commissioners and names one of them chairman, and the staff is like a total of 1,100 people. That's it for the whole country. And half of those people are doing antitrust cases, and so only half are doing consumer enforcement. So if you look at, 550 are doing consumer enforcement, and some of those aren't attorneys, they're paralegals or support staff. So it's a really small agency. And they have divisions and headquarters in Washington. They've got 7 or 8 regional offices around the country. But they're small. Each one of these offices and divisions are pretty small. So they have to really pick and choose which cases they want to go after. And there's tons more that's out there that you're wondering, why didn't they go after that? Why didn't they go after that? Well, there's only so many of them, and they kind of pick the lowest hanging fruit. They go after what they think is the most slam dunk, case they can bring and win, and that's the most egregious conduct causing the most consumer injury that's ongoing. So with all those standards, that's how they kind of pick and choose what to go after. It's really a small agency. They can't possibly go after every single one that they might want to. Yeah. Uh-huh.
Suppliers in the U.S. How does that affect? Do they have jurisdiction to go after the merchants? Will they go after the merchants outside?
theoretically, they do have jurisdiction, but as a practical matter, it's tough for them to go after them. They have, actually, they do have stronger than ever international ties with other countries, counterparts to the FTC. So they have brought many cross-border cases over the last 10, 20 years, starting mostly with Canada, but since then they've done UK, Australia, New Zealand. I think they're looking to do probably more international. And it could be the situation you said where it's just the consumer, quote, victim in the U.S., but they could also, if they wanted to, go after anyone with a U.S. connection or nexus, but the only consumer victims are in the foreign country. But they changed the language in the FTC Act 6 or 7 years ago to give the FTC authority to go after exactly that situation. It's only a foreign web page, it's only foreign consumer purchasers, but the company has some connection in the U.S., some operations in the U.S. to make that happen. The FTC can go after that too. Will they? It depends. Again, they're such a small agency that they'd have to really pick and choose. There was one, I think, announced last year where it was a .co.uk ripping off consumers in the UK, but there was a US connection. So they got together with Office of Fair Trading in UK and brought this case with UK's help, where it was actually not American victims. It was British consumer, quote, victims. So yeah, anything's possible, but it's a question of how they devote their scarce law enforcement resources. Any other questions? I'll stick around if you just want to come up and ask me. Okay, thanks a lot. Okay.